difficulty is when you're drafting the operating agreement, REITs have tons of detail, tons of requirements. And now it should be relatively easy to meet in most real estate deals. But unless you know what those are, unless you know what that compliance is, it's very hard to draft. And somebody might simply put in, one sentence saying, this shall be REIT compliant. But if you don't know what that means, you shouldn't just accept that sentence. I mean, you have to make sure your folks know.
And that happens, Steve, right? I mean, I've been involved in deals where I'm not representing the REIT, and REIT counsel will just put in the management section of the LLC agreement that the LLC is going to do whatever it needs to do to make sure that the REIT qualification of the investor is not disturbed. And to someone who doesn't realize the implications of that, that can be a very explosive provision.
So my checklist, I have a checklist for the general business guys in any joint venture. I said, if you see the word REIT or code section 856 anywhere, you need to bring in a tax specialist that knows REITs. There's a lot of negotiation there about who's responsible. And REITs have a lot of limitations, like generally holding the assets for at least 2 years before you could sell them. And a certain income is bad. Maybe it might force you to earn that income through a taxable entity. So there's a lot of stuff that definitely is just things to think about. Other things in the JV agreement, you will have concepts like withholding taxes, income allocations, distribution rights, management rights, and you're getting into all that stuff. And it's broken down into sort of sections. And I would say, in my experience, most agreements follow this general ordering. The main things I see that differ, sometimes people put the definitions in the back versus the front. Sometimes the allocations and the distribution sections can be reversed. But for the most part, they start with what I'll call prefatory language, a little background, right? Is this an amended and restated agreement or just a brand new agreement? How did the property get in here? Who are the members? What's their names? What's the scope of business? Has there been prior amendments, people going in and out? People just like to know that history, and it can be relevant. So I always find that prefatory language, it can be in a whereas clause, or sometimes they call it recital, sometimes they call it a preamble, and lots of terminologies for the same thing. But Brian, I assume you read your prefatory language and every time you read one.
Every case, you got to read every word. That's my view. You don't know what somebody's going to try to slip in into the document. Now, if somebody's going to try to slip something into the document, they're not likely to do it in the preamble of the document. But there might be a description of the history that may not be correct. And so you're going to want to make sure that the history's explained correctly. And sometimes people will put in more history than they need, and there may be tax sensitivities or other concerns that would lead one to say, hey, we really don't want to say very much about the history. We want to be more quiet, more silent.
Well, and sometimes that history might say that somebody's doing a part contribution, part sale. And then that should alert you to say, well, gosh, there might be some tax there. And guess what? There might be some tax planning there if you're getting some cash back. So all that to me is really important. The next section is really getting into the administrative detail, the name, the offices, the term, purposes and powers. It's often extremely broad, but at least it gives you an insight into what's going on. Now, theoretically, we would have had a term sheet ahead of time before drafting this joint venture agreement. I don't always see that.
Often you don't. And I guess some things here, again, and focusing on what we have here, what you may not need. Every now and then I'll see a venture document that'll have a term to it. And they'll usually extend that way out into the future, but often you don't need to have it. Most state statutes, you can have these entities be perpetual. So if you don't need a term, no reason to include one.